Previously on Drivel to Civil, Gavin and Damian demystified some of the complexities of English law as they dove into the essence of constitutional statutes, statutory legislation, and the rule of law. Damian provided us with an understanding of the differences between common law and statutory legislation, and how they protect your natural rights and liberties. To gain a better understanding of this fourth and final episode of this series, make sure you go back to view episodes 1 through 3 before proceeding. As always, we appreciate your support.
This statutory legislation does not supersede primary legislation, constitutional law.
Law matter, right? And also, I think in that case as well, that hearing you fired a shot across the bow, didn't you, against the court agents to just let them know to behave.
Yeah, we understand the government is set up to protect the rights and properties. Okay, well, the checks and balances are these constitutional statutes. Common law is being written into a lot of these statutes. Lex scripta, lex non scripta, which is written. And Sir Edward Coke, wonderful people. I advise you start Googling him, start reading up on him. He was instrumental in the creation of the Petition of Rights, 1627, which really limited the king's power and prerogative at that time. He was really for the people. A wonderful man. He was a champion of the rule of law, declaring the king to be subject to the common law, not above it. This is where you learn.
That's pretty powerful, that statement and that fact then, what you've just said.
Yes.
Very powerful.
This is why I call him our highest ranking public servant.
Which is the truth, right?
Yes.
Which is where I think we're on the same page. The coronation oath for me is the preeminent statute of statutes. It's kind of right at the very top. Everything comes from it.
I think just that statute, you can get all your grievances and redress just on that.
I agree, especially when you're dealing with courts, given that they have to swear their own oaths, right?
Yes. So the courts are all under His Majesty banner, HMCTS. Okay. So they have to respect that he's the highest public servant. We are his subjects, that he has signed on to a specific act that's a common law constitutional statute, right? Now, he has said that he's going to maintain the statutes, laws, those are the known laws, we're going to go into those, and customs, that's the common law. So he's saying the statutory law, legislation, the known laws and customs, the common law. That's it. You've got to be able to define the terms. And all the people, well, the people's not a creature of statute, that's us. The creature of statute is the inhabitants, which is a member of a corporation. So, and all the people, us, and inhabitants thereof. The inhabitants is the creature of statute. People aren't. In their spiritual and civil rights. Your spiritual, this is where you can smash the whole COVID restrictions and regulations. Your spiritual and civil rights. Okay. Right. Well, my religious beliefs, my spiritual rights dictate that I'm not going to wear that. I'm not going to cover my spirit. Right. My sacred breath of life. There you go. So if you're made to wear that, then they're violating your spiritual right. And my civil rights, which are my private rights. I don't want to wear that. You're violating my personal space. Get that away from me. And then you hit them, well, why are you making medical determinations? Who the hell are you? Go away. So, it says here spiritual and civil rights and properties. It's all in there. With relation to ancient laws and constitutions. It's all there. So you've got civil rights violations, right? So you could hit somebody with a civil rights complaint using CPR, a civil action, an action brought to enforce, redress, or protect private rights. So the right to say, I think you get all your remedy just with that one statute. So people want to talk about common law. I mean, just think common law marriage is a legal marriage, despite being non-compliant with the requirements for a statutory marriage. It's a legal marriage. It's recognized as such. Okay. Common law remedies and equitable remedies, common law doctrines, my two favorite, privity of contract and respondeat superior, which is vicarious liability. Mentioned that before. You know, and then you've got negligence, damages, tort law. Right. So when you understand the common law remedies, you understand they are narrow in their application. They're rigid rules. So then if they're not fit for your purpose, then you use the equitable remedies. Yeah. Okay. Common law offences, type that in. Okay. So a whole lot of common law is merged with statute, as well as remaining unwritten. It is also very prevalent within contract law and the rules of settling, transferring, and acquiring estates and properties. Yeah. Right. There's two types of statutes. The statutes made before the time of memory and those made within the time of memory. Now, have you heard those terms?
I've actually not heard those terms before, no. So I'm learning something here.
It's important I'm not giving a fucking boring history lesson. This is not what this is all about. It's just important to know how we got here. And the way you do that is to know where you've come
go back.
from.
Yeah.
Yeah. Where have you come from to get here? Right. The statutes before the time of memory are those made before. This is a fact. Okay. This is in legal terms. This is how they define it. The time before memory is before the beginning of the reign of King Richard I, which was 6th of July, 1189. That's the time before memory. So the statutes that were made before 1189, the beginning of the reign of King Richard, are the time before memory.
What defines that, though? How has that been the line in the sand that defines time before, time after? It wasn't a trick question. I was just curious if you don't know an answer.
That was decided. I would have thought through both Lords, temporal and spiritual, and the Commons.
Yeah,
that's where they've come up with that prefix. So it's just that's what it is. It is what it is. So that's and you can check that. You can Google. You do what you like, but that is a fact. So within the time of memory is from the beginning of the reign. So from the 6th of July, 1189.
Mm-hmm.
And those statutes or acts of parliament, this is in a legal recognized sense. Those statutes or acts of parliament made before this time that have not been repealed or altered by subsequent acts of parliament or contrary usage are now seen as lex non scripta, unwritten laws, and part of the common law. Yeah.
All right, folks. So that's drawing a line with the history lesson. What we're now going to do is dig into our rights. Back to you, mate.
Right. What we have, so forget the statutes for a minute and understanding statutes, constitutional with the common law written in, and statutory legislation, two different things, right? We know that the general customs are common law. What about the known laws? Well, those known laws protect the absolute rights of individuals. Okay. So what we have is what is a right, okay, and prohibiting what is wrong. Think about that. So consider the rights that are commanded, and secondly, the wrongs that are forbidden by the laws of England. Now, the objects of the laws of England falling into a fourfold division. So we've got the rights of men, individuals, okay, whereby such rights may be either acquired or lost. The rights of things, which means also of acquiring or losing them, private wrongs or civil injuries with the means of redressing them by law, which is the due process of law that we've done, observance of, and public wrongs or crimes and misdemeanors with the means of prevention and punishment. Okay? So let's have a look. We've got here our rights, which are due for every citizen, which are usually called civil duties, and secondly, belong to him, which is a more popular exception of rights, or jura. That is the due from one man or a set of men, they must also be due to another, and to have protection as of the duty of the magistrate. Yes. And yet they are reciprocally the rights as well as duties of each other. So our duties to one another, comes back to the natural law, cause no harm, injury, or loss. I mean, it's common sense, isn't it? These are common sense laws. Allegiance is the right of the magistrate, and protection, the right of the people. Now, are we getting that in the magistrates' courts? No. So we have to circumnavigate them. So when they're going through their little dog and pony show with the council tax and with these fines, because now they're doing exactly with the schools and with the councils on the education side, they're doing exactly what they do with the with the fake summons, with the liability orders, everything, this all coming from the council, isn't it? And they're having a private tribunal. So they're just hiring literally a room within the public court venue. And you go in there with the belief that actually you're walking into a courtroom proper and getting due process, but you're not. It's a private tribunal. You are going into McDonald's, except you don't work for McDonald's, and suddenly you're being beholden to their rules and regulations. You're like, well, hang on, I don't work here. What's going on here? And then they fine you, and then you're expected to pay, and they use fearful words. We're going to do this, we're going to do that. Well, there's the recent case, isn't the High Court?
Last Friday, you mean?
Yes.
Yep.
Where I think Mr. Leighton, has he not sued their Bristow and Souter debt collection agency that they pretend to be High Court enforcement or court enforcement? I mean, the whole thing is a fraud from start to finish. And I ran a similar thing on the education side, helping somebody who unwittingly would admit they shouldn't have ignored the 2 fines that they got. I mean, when I was threatened with a fine, I nipped it straight in the bud. Okay. And that was with the education welfare officer, with the school, and I heard no more of it because I left them in no doubt. Hey, look, if you're going to continue this, I'm going to sue you. That's it. I'll sue you, Mrs. Principal at the school, and I'll sue you, Mrs. Education Welfare Officer. That's it. I'll come after you both. No problem. And I don't even mind, because I'll sue you in your official capacity and I'll sue you in your individual capacity, which means I'll leave you sleeping under a railway bridge. Okay, I'll come after your house, your pension, your car. I'll take clothes off your back and I'll leave you penniless under a railway bridge. Yeah, that's
All
the
for a
power we
fine.
have.
Yeah, absolutely.
So he didn't nip it in the bud. 2 fines, one after another. They duly ignored, and then suddenly this whole mechanism started where the council initiated a charge. Right, that was the first part. So look at that. So I always just break it down to basic premise. So, okay, how does a council initiate a charge? Are they the Crown prosecution system? Are they a police officer? No. Okay. So what authority And what observance of the rule of law have they done to initiate that charge? They can't. They can't. So that is their foundation of sand immediately. Take that. But then the next process where suddenly now the court are in cahoots, right? The court have now escalated this initiated charge, of this unlawful piece of legislation, yes, where I wrote, hold on, off camera, this was very important. So when they're not following rule of law, or if they're not following due process, or if legislation is, in a manner of speaking, unlawful, right? Basically, you can never find the bloody thing that you've written there. Because as you said, Gavin, here it is. Right. Really important, this. So when they're acting in this way, right, so what you've now got a magistrate's court, an administrative court, is acting outside of the rule of law. So it's a breach of the rule of law, therefore a breach of their public duty. When you've outlined those facts and they continue to try and cause harm, they continue to act unlawfully, now they're in misfeasance. Okay, because you've told them they can't continue. And the court manager, who I went after, got her name, is now in a conspiracy, an active conspiracy with this chap, with the Children's Service, the Education Welfare. Right? It's a conspiracy because they're trying to extort money. Aren't they? And they
absolutely true, mate.
Outside of the rule of law.
Just on a note, like, although this is sort of being kept to like the schools and PC financial schools, but if you go back when it starts with the council, it's always the same shit. So the theory that you can apply this theory to everything that they do: business rates, council tax, education, planning, like everything is the same stuff. So just listen to what Damian's saying there, but you can apply it to anything. So if you're running foul of planning, same principles apply.
Yes, yeah. So this is really important. This comes from case law. This is Lord Hodge, actually, Lord Hodge addressing the bar in 2011, but it's out there in the public forum. Where he states the rule of law requires judges must retain power to insist that legislation of an extreme kind, which attacks the rule of law itself, is not law which the courts will recognize. So that wipes out immediately section 444, subsection 1 and 8 that they use to continue this dog and pony show. Yeah. So we sent a letter for action, talk letter to the court manager and Majesty at that specific council in the Education Welfare Department, Children's Services. And then the chat that I was helping get through this sort of, well, it's been this amount of time. What do I do now? I said, nothing. Have you heard from them? No. So at the end of the day, in that letter, that was as much for you as it was for them. You have to learn this. You have to learn. I said, read what I wrote in there, right? And now anything they do after this point, you collect the evidence. It's now evidence of a crime. And I've put out the legislation. I wrote all the acts. There was about 5 or 6 acts that if they continued what they were doing, they'd be contravening, and the sections. I said, you've got so many causes of action, and if they break each and every section, you'll have all the elements. That's been explained to them. I said, they've got nowhere to go. But this was for your eyes, for an education. There's no point you asking me. So read it. Read what I've written. They've got no place to go. But I get it. It's confidence. If they're still learning the knowledge, and still learning process. I said, they've got, if anything more that they do after this point now, it's just criminal action. and you just collate the evidence, you shouldn't hear from them. And if they do, do their thing in court, fine, don't go. At the end of the day, let them do their dog and pony show. And any paperwork then comes is more evidence. It's another exhibit. I said, well, so we'll do a civil action and then we'll do a criminal complaint. We'll file those in the county court, the high court.
And that's the thing, just as a sort of strategy, don't get into your defensive position. Like, that's a common thing. Start defending what they're claiming to be true, because then you're going to be pulled into that magistrate circus and you're going to lose. They'll railroad you. It's like Damian's saying, if you understand your own rights and how they're protected, your position is attacked from day one. You don't give any credence to what they're giving you in terms of paperwork. That's your evidence. You go back in and you serve them. And there's each to their own in terms of how you do that. Damian's got his own style, I've got mine, but you'll work it out for yourself, But yeah, I don't know what you think about that. We've never spoken about it, but it's just very much play the strategy, play the game. Chess is the analogy I always use. No room for emotion. You're positioning yourself on the board to get them into a position of check or checkmate. So there's a lot of talk about, you've not won in court, you don't go to court. You shouldn't need to go to court if you get the bloody thing right. You're nipping it in the bud straight away, so they withdraw. And what you do is you give them an exit. And the exit, whilst painful for them, is kind of the lesser of all the evils, because if they don't, then you're escalating. And a lot of the time, you don't even need to get to a letter before action. A lot of the time, it's just a really I call it a notice of liability. That's what I put in. And I outline all of the facts. And then I let them know that if you don't, the next one is going to be the letter before action. But generally speaking, because all of these courts are bullshit, it's very easy for them to just get rid of the problem. And if they get rid of the problem, they remove their liability. Job done. Don't know what you think on that one, but
no, I totally agree. A letter before action, or I send them a tort letter. Same thing. It's exactly the same as a notice of liability. You're outlining their torts, so it's the same thing. And I do that, and I give them a way out. And if you do continue this, these are the laws you're breaking. Your own legislation. And you back it with the facts, and somebody there, you'll get a legal adult in the room that will go, yeah, he's right. Okay. We need to stop. This one knows. And from what they've said, it looks very clear. They also know how to litigate. So we got a problem. So, that should make it go away. But, it's understanding your rights. The rights we've got, unbelievable. I'll continue with that. The rights of man considered in their natural capacities are of two sorts: absolute and relative. Absolute, which belong to particular men as individuals, relative, and also as members of society. But our absolute rights of individuals are so primary, right, as belonging to us in a state of nature where every man is entitled to enjoy, whether out of society or in it, right? With regard to our duties of society, which a man is bound. Let's come away from that. Now, the principal aim of society is to protect individuals in the enjoyment of those absolute rights. Is that happening at the moment? Society seems to be violating our rights because we never knew we had them. Now, this is the problem. Unless you enforce your rights, then you don't have any. And this is the way it's got to be. I'm going to be writing to my school because I had a letter basically where the letter from the school, it's a school attendance update where they're basically now pushing a government directive. So this principle has become nothing more than a modern day brown shirt. Think about that. Pushing the directives of a regime. That's where we're at. Well, I push back. So she'll be getting a legal letter from me explaining how she can't do and say that none of this is enforceable. Threatening fines, and now they've brought in sections. I mean, they just show that they don't understand. Section 7 of the Education Act 1990 protects our rights and our ability to educate at home or educate on holiday.
Just explain to folks there, because they use that all the time, but they kind of forget the little bit at the end which says or other.
Yes, right. This is interpreting statute and using the rules of language. And these rules have been around since the 17th century, common law with Sir William Blackstone. Section 7. Now, this is what the school has cited. Right. Section 7 of the Education Act places upon parents a duty to ensure their child. So, okay, a parent is a creature of statute. A child is a creature of statute. So, places upon parents a duty to ensure their child. Now, let's just come into that statutory world for a minute. So, I'm now going to identify as a parent, and my son, my offspring, a child, receives suitable, efficient, full-time education, either by regular attendance at school or otherwise. Right. These are the rules of language. Or is a disjunction, which means in statutory terms, you've either got to do, the statute's commanding that you either do this or this. Those are the two elements, yeah? Right, so I've got to have him in school or otherwise. Okay, well, that's ambiguous, but define it, it means in a different way. That's from the Oxford and Cambridge University definitions. Can't argue with that, right? So, or otherwise. Well, okay, so I can educate him on holiday then. Or I can educate him at home, because you don't have a legal duty to have them at school, but you do have a legal duty to educate. That's in their statutory world. You don't legally have to have them educated at school, but you do legally have to educate them. But this is saying you can educate them where you like. But then underneath that, they've added, this is the first, this triggered me actually, where they then got underneath that section 444, section 1 of the same act states that where a parent, this bit contradicts the first bit. You got section 7 saying what I've just defined, section 441 saying something completely different, where a parent of a child fails to ensure regular attendance of a registered pupil, another creature of statute, at school. Now, I attack that with, which is what I did with helping this other chap. Okay, can the school or the council show me where in the registration process we gave power of attorney of the child to the school, to the council, or to the state, where we gave away or granted our rights away, that of myself as a father or my son, where we gave away our individual rights protected in the known laws. Show me where in that registration process, show me where we gave away power of attorney of our offspring, where we registered away our rights. Show us. You're saying we've got to do this. Show me where we gave away those rights, where we gave power of attorney, and where we contracted with you a common law contract to be bound by the terms and conditions of this fucking act. Show me. They can't, because it never happened. So this is a whole dog and pony show in itself. And just remember that if a legislation is so against the rule of law, which this is, I'm going to read it, states where a parent of a child fails to ensure regular attendance of a registered pupil at school, the parent of the child shall be guilty of an offence. Okay, let's define the term. An offence is a commercial penalty. Okay, against that section, the local education authority may, it may, can it? Well, I may not. Right, where necessary, start legal proceedings in the magistrates. Oh, your favourite, the magistrates court, where you circumnavigate the rule of law. You f***ing peanuts. Right? In the magistrates court under this section against those parents concerned. Alternatively, section 444B, you'll love this, of the same Act empowers the local education authority to issue a fixed penalty of either 60 or 120 quid. Now, hold on. Let's rewind. So I'm reading that as, alternatively, Section 44B of the same Act empowers the local education authority to violate the Bill of Rights, 1688.
Yep.
No, it doesn't. So what you've got here is a dog and pony show going on, where these morons at the council believe that this gives them the authority because it's been written in there. It's actually a state directive that they're enforcing. But when you understand the known laws, your rights, the rule of law, no, this doesn't. And anyway, I mean, just that 444 contradicts Section 7.
Yeah, or otherwise.
It's once you peel it back, you just see it's ridiculous.
It's no wonder they're so damn ignorant and so arrogant in their position. And this is why we're on the same page and we're saying this now. It's like, this is why we've got to learn our rights, learn how to sue them, and understand tort law, because it's the perfect mechanism to sue them. And it's actually quite simple when you get your head around it. For me, that's the only way we it's not about bringing the system down. It's the only way we educate them as to what they're doing, because they don't even understand their own rights. Yeah, this shit's got to stop.
What is the system? Think about this. You know, I had this with somebody banging on about the council. I said, well, what is that? I said, when you go to court, you're not taking the building to court, are you? I said, the council is two things. It's a building, which you take all the employees out. They're the problem. Take the people out of it. These indoctrinated people, you know, with these silly directives, which contravene the known laws of the land and superior statutes, the common law, the constitutional law. Okay. So take these people out. You've got an empty building and you've got a two-dimensional construct, right? Defined in Companies House on a piece of paper or on a computer. So you can't take that to court and you can't take the building to court. And the building can't answer itself. It's these people. And this is why I say, who is causing you the problem? Who is causing you the harm? Oh, the council. No, somebody at the council is causing you the problem. Give me a name. And they then name, and then give me the time. I said that. So you go after them. It's them. They're responsible. They're violating your rights. And that's break it down to its simplest form. Now, the absolute rights of man considered, this is in our known laws. It's written in. The absolute rights of man considered as a free agent endowed with discernment to know good from evil, with the power of choosing those measures which appear to him most desirable, are summed up as a natural liberty of mankind. This natural liberty, which is rights, consists properly in a power of acting as one thinks fit without restraint or control, unless by the law of nature, being a right inherent to us by birth and one of the gifts of God to man, his creation, which endued him free will. Okay? Now we've got here those rights. How far, right? Those rights are enshrined in the laws of England. Take notice those absolute rights and provide for their lasting security. Okay? This is all in the commentaries of the laws of England. The absolute rights of every Englishman that are founded on nature and reason, right? Seen and written in firstly by the Great Charter of Liberties, which were obtained sword in hand from King John, right? And afterwards with some alterations confirmed in Parliament by King Henry III and his son. Now you understand what that charter is, okay? Call it by the correct terminology, which is probably why when people mention the Magna Carta, it's not recognized. It is the Charter, the Royal Charter, or the Magna Charta, right? Which is also written into the Nova Statuta. These are the common law statutes. Look it up. Nova Statuta, right? Which charter contained a very few new grants, as Edward Coke observes, the most declaratory of the principal grounds of the fundamental laws of England. Right? Afterwards, a statute called Confirmatio Chartarum, whereby the Great Charter is directed to be allowed as the common law. All judgments contrary to it are declared void. Right?
That's big.
That's massive. But you've got to know this, and you've got to be able to define it and put it in your pleadings, your complaints. Right? We've then got these written into the Habeas Corpus Act, the Bill of Rights, where the King and Queen, upon their declaration, and they do claim, demand, and insist upon their undoubted rights and liberties. The Act of Parliament itself recognises all the singular rights and liberties asserted and claimed in the said declaration to be true, ancient, and indubitable rights, meaning they can't be taken, of the people of this kingdom. Those liberties and rights were asserted again in the Acts of Settlement, whereby the Crown was limited by this, and some new provisions added for better securing our religion, laws, and liberties, which the statute declares to be the birthright of people of England according to the ancient doctrine of the common law. Okay, so the Declaration of our Rights and Liberties, the rights themselves defined by those statutes, give us private immunities, right, which reside in natural liberty and required by the laws of society, right? Now, this is important, that your rights cannot be sacrificed to public convenience. What has happened in the last 3 years? What happened?
Exactly what, well, they've done exactly what you've just said there. The thing they cannot do, they've done.
This is in 17th century's law scholar writing, the laws of England, our law lords. This is your redress, where it says it's not required by the laws of society to be sacrificed to public convenience, right? And your natural liberty not to be given up by individuals. These are the inheritance and the rights of mankind. So your rights are not to be sacrificed to public convenience. Yet we were told we had to have this, right, and that for the public good, and that your individual rights were no longer sacrosanct. Well, hang on, no, that's nonsense. It says here in the commentaries of the law of England that actually that's not so, right? That you have the right of personal security. These are the primary articles of these laws of England. The right of private security, okay? Where was it? The right of personal liberty and the right of private property. And we got huge rights. The right of private security is your legal and uninterrupted enjoyment of your life, your limbs, your body, your health, and your reputation. All right. That's massive. And that life is an immediate gift of God, a right inherent by nature in every individual. Okay? Now, there's a lot more, but I'm addressing the important points in here. The preservation of a man's health from such practices as may prejudice or annoy it. The security of your reputation or good name. And you've got the personal security. The law of England regards as, this is massive. Next to personal security, which the law of England regards, asserts, preserves the personal liberty of individuals. All right. Which means you can't be in prison. You can't be violated unless by observance of due process of law.
Just two quick things on that point. Council tax, imprisonment. There you go. That's what you're using, right? You don't even need to use that, to be honest with you, but there you go. This new bill that says they can put you in prison for not putting your smart meters in. There you go. They can't do all of this shit, people. So lose the fear.
Now, this is huge. This is massive because the way that they're trying, notice that they're not coming at you through the county court or through the high court, because they're two courts that observe due process of law. And this is why in that judge is summing up with regards to the fella suing Bristow and Souter, the fake court enforcement, actually a private debt agency collection, said, we've got to have a review on what the councils are doing here because they're obviously not following due process of law.
He condemned it, actually. That was his words, condemned the process.
You don't get a more serious term than condemnation of their procedures, because this is a proper judge. This complaint reached a proper judge, an adult, and he's like, "What are they doing? You can't do this. There's no observance of due process of law. They've breached the rule of law. They've breached public duties."
This is why, guys, they and it's wrong to keep going to the magistrates to try and stand on this stuff because you won't get anywhere, and they keep you in that little merry-go-round, so you can't get out. So
It's a conspiracy.
It absolutely is. Don't get into a defensive position. Learn this stuff and sue them. It's that simple. Stop it that way. They're the ones liable. Hold them to account.
Sue the man or woman at the council and their CEO through the common law doctrine of respondeat superior. Let's sue the court manager. There's your three.
And I say sue them, just to clarify that. I'm not saying you necessarily, as I say, you follow the protocols to do so, but generally, if you nip it in the bud, strongly worded, factually correct, by the law, all the facts expressed correctly, with your causes of action in a letter before action is generally all you need to shut the whole thing down.
And you've lost your fear because you have an understanding of what they're doing. You can see the conspiracy unfolding in front of you. You just laugh. You just continue incriminating yourself, people,
Exactly. Exactly it. Yeah.
Yeah.
Sorry.
No, exactly that. You and I are on the same hymn sheet here. At the end of the day, everything they're doing is a conspiracy, and they're breaking so many of Parliament legislation that they're bound by, public office. You just, as I said, mate, you said, well, what do we do next? I said, just nothing. Just
let them do it. Yes, exactly it. We had one yesterday, just as an aside. This is a council.
Them and letting them hang themselves.
Exactly, because they're so ignorant. We had one. There's obviously different ways to approach council tax, but they're always egotistical, and I always think they know best. And you can play that. And we actually had a revenue manager. It blew my mind because I listened to the recording, and they've actually given us the email confirming that there's a lot of things they confirmed, but they also confirmed that this individual was not legally trained, but they would act as the court agent on the day in the court. What? But they've given us that. They've literally typed an email out and confirmed quite a lot of things that they are not allowed to do that would kind of define them as acting as the judiciary. So you've got that Local Government Act 1898. They can't do this stuff. They are that clueless that you can bait them into giving you everything you need to go hammer them.
Just by saying, where do you get your authority? How are you doing this?
Exactly it.
They incriminate themselves, Gavin. They are so willfully moronic.
We've got magistrates even confirming that stuff, not interested. We're only going to look at the local government finance. Like, that's the only thing that counts. It's like,
But they've been doing it for so long, it's become a practice and a custom of theirs.
Yeah, they've got away with it for so long. That,
and I
think right.
A lot of them don't realise that actually what they're doing is unlawful.
It's correct. And that's why, as I say, going back to that letter before action, if you know what you're putting in it, it's generally all you need to do. They'll back the fuck off straight away because you're giving them an exit and they want out. Especially in council tax situations when you go after the court agents, because ultimately they even know it's got nothing to do with them. They know what's really going on. So when you're holding their feet to the fire, it's kind of like, well, they don't want anything to do with it. It's got nothing to do with them. So when you do that, you bring the council in by default, then you hammer them that way. Quite a few ways to get at it, but just it's the liability, personal liability that matters.
And after they've done their dog and pony show, okay, right, I want a certified copy of the case file, please, as is my right through due process.
And it doesn't.
They can't provide you anything.
Yeah,
because they haven't followed due process. So they're morons, and they just give them a length of rope and let them hang themselves.
True.
Them.
Yeah.
So you've got the preservation of a man's health from such practices as may prejudice or annoy it. So you've got personal security. The law of England regards, asserts, and preserves the personal liberty of individuals. It got so much in here, Gavin. Whereas there was something that was a bit further on, where they can't confine you, imprison, keeping a man against his will, a private house, detaining. The law so much discourages unlawful confinement.
I just had a thought, actually. This has just occurred to me. What you're saying is using that, contempt of court for civil matters. That would be perfect for that, wouldn't it?
Yes,
Because
Yeah,
they can't jail you for contempt of court for civil matters.
the confinement in any wise is an imprisonment. So keeping a man against his will in a private house, putting him in the stocks, so like that, arresting or forcibly detaining him in the street is an imprisonment. And the law so much discourages, basically saying you can't unlawfully confine, or if a man is under duress of imprisonment, which we before explained is a compulsion by an illegal restraint of liberty until he sells a bond. He may allege this duress and avoid the extorted bond. If a man is unlawfully imprisoned, procure his discharge. There's so much in here that you can go against. If there's no cause expressed, that the jailer is not bound to detain a prisoner, to the law judges in this respect. And a natural and regular consequence of this personal liberty is, the Englishman claimed that to be his right. The third and absolute right inherent to every Englishman is that of property, which consists in the free use, enjoyment, and disposal of all his acquisitions without any control or diminution, save only by the laws of the land. The original of private property is founded in nature. The laws of England, in point of honour and justice, are extremely watchful in ascertaining and protecting this right. Moreover, the regard of law, so great is this regard of law for private property that it will not authorise the least violation of it, not even for the general good of the whole community. Right?
Would you say planning? We have a lot of that stuff going on at the moment. All these planning laws with the councils, that is perfect, isn't it, to hit them with?
Yes. Yeah, they're in violation.
Personal liability.
Also with taxes, nor is this the only instance in which the law of the land has postponed even public necessity for the sacred inviolable rights of private property. Right? So it's saying that the law of the land says that, no public necessity can violate the sacred rights of private property. All right. It says here, for no subject of England can constrain to pay any aid or taxes, even for the defence of the realm or support of government. Think about it.
Wow, that's big.
No subject of England can be constrained to pay any aids or taxes, even for the defence of the realm or support of government, but such are as imposed by his own consent. This here writes it. So those are your primary rights of personal security, personal liberty, and public property. And I'll leave it there because you people need to read up on that.
Yep. So we'll have if I can get one, there'll be a link to that in the description. Just to wrap this one up, then you've got the law, the jurisdictionary course, which is an absolute must do. If you really want to just bring this whole thing together, you've got to research. A good litigator is a good researcher. Damian's a master researcher. You can see that, right? You get that information, you combine it with the knowledge you're bringing into the you're learning from the law course. Get your head around taught. Go get them. That's simple. And when that's said, Damian, thanks, my man. We'll be back.
Pleasure.
We're doing another big one next week. I'm not sure when that will come out, but we'll be back next week with a bigger one. And what are we going to go into in that one, Damien, just to give them a heads up?
Well, we can really drill down on family law, because I think that has a
that's a
huge
big one.
effect on people. Definitely. So that's important. We could do a good hour on that, and how to navigate it, how to negotiate it, and how to get your wins in the family court. And I have very positive experience of that. So, we'll go through that and your do's and don'ts.
Good man. All right. See you on the next one. Thanks for watching.
See you later. God bless.
Do you find the legal system overwhelming and wish you had the knowledge and skill sets to control judges, persuade attorneys, and win your case? Well, look no further. Sovereign Empowerment is proud to announce our partnership with Dr. Frederick Graves so that we can bring you the Jurisdictionary Law course, How to Win in Court, your ultimate resource for mastering the courtroom. Unlock powerful case-winning strategies as you learn to control judges like never before. This comprehensive course eliminates guesswork and empowers you to navigate the legal landscape with absolute confidence. With step-by-step instructions, flowcharts, and outlines, you'll have all the tools you need to persuade and control judges in any case or court. Learn from a seasoned attorney with over 40 years of winning experience, who has distilled his expertise into this comprehensive program. Access everything you need in one single package, including sample forms, video seminars, audio clips, and in-depth case-winning classes. Learn at your own pace, anytime, anywhere. Our 24/7 online access allows you to tailor your learning experience to fit your schedule. Access the course on your smartphone, tablet, or computer and become a legal master whenever and wherever you want. Benefit from a suite of powerful tools, including a free online legal research tool, a legal dictionary with common sense definitions, and an exclusive Q&A forum to connect with fellow students and obtain expert guidance. Good people have suffered too long at the hands of power because they just didn't know how to fight back. Now, in a matter of just a few days, you can acquire the tools and knowledge that takes law students years to achieve. Can't afford a lawyer? No problem. With the Jurisdictionary Law course, you'll gain the skills to win your case without expensive legal representation. Alternatively, equip your own legal consult with the tools and tactics to fight effectively on your behalf. Level the playing field and secure your victory. No matter what court, civil or criminal, conquer any courtroom challenge with ease. This step-by-step guidance ensures a quick and straightforward learning experience, empowering you to navigate the legal system with bulletproof confidence. As a testament to your newfound legal expertise, you'll have the opportunity to complete a final exam and receive an honorary law degree upon successful completion of the course. Showcase your achievement and establish yourself as a force to be reckoned with in the legal arena. Dr. Graves believes everyone deserves access to legal knowledge. That's why we offer the Jurisdictionary Law course at an unbeatable price. For less than the cost of a 1-hour legal consultation, you'll gain unlimited access to this complete program for up to 2 full years. Take control of your legal battles without breaking the bank. How to Win in Court has become the most trusted law course worldwide since 1997. Don't miss out on this exclusive opportunity to gain the upper hand in the courtroom. Enroll in the official Jurisdictionary Law course today and unleash your legal power. Click the link in the description below to become legally empowered today.